Good afternoon, everyone. My name is Chen. I'm a lawyer here with Samfiru Tumarkin at our Vancouver office. Uh, Hopefully, we've got. I can't see anybody, but I can see your messages. This is our firm's Facebook and YouTube live event. The main purpose of these sessions that I do every 2 weeks, it's essentially it's an opportunity for anybody to come on and ask any questions about their employment law issues. I'm here for the next 29 minutes. So I welcome any questions that anybody may have. If you just type it into there should be a text box in front of you. So if you type it in, I'll be able to see it on my screen here. But I mean, the main purpose of this is to answer questions from the audience. So please don't be shy. I encourage everybody to ask as many questions as they want, or I'll try to get through as many of them as I can. But if nobody has any questions for the time being, I think my message box should be working. I will go ahead and talk about some current events in employment law. So, and please feel free. I mean, anytime, even if I'm, blabbing on about a certain subject, please type in your questions anytime. Feel free to interrupt me as much as you want. Like I said, I'm here to answer questions, not so much to blab on about the state of employment law today in BC. So as I said, I'm a lawyer in the Vancouver office. I mean, I'm generally aware of the law in other provinces, but I'm going to try to refrain. So if you're in BC, I can do my best to answer any questions you might have. If you're in another province, feel free to ask a question, but I'll try my best to answer generally, but I might not be able to. I could direct you to one of my colleagues who, we also have an Ontario Facebook Live event as well. So without further ado, I think a topic that a lot of my clients have been asking me about, and a topic that I've seen in the media a lot recently, is the issue of employee privacy. And I mean, normally, privacy in the workplace, you think of surveillance cameras, you think of, software on your work computer that tracks everything you do. It's become a more prevalent issue because of COVID. I'm sure that some, people listening in right now can relate. It's, because you're working from home, or some people are working from home, particularly those people that are in office jobs. A lot of companies nowadays are trying out a hybrid model, right? So half the week, I don't know, 2 or 3 days a week you're working from home, or maybe you have the option to work from home permanently. But it's certainly become more of the norm since COVID hit, for obvious reasons. So the issue of privacy has really, it's become a bigger issue than it used to be, because how can an employer monitor you while you're working from home? The question of, I guess the first question is, should they try to monitor you from when you're working at home? That's more of a a business policy question. I'll try to refrain from whether it's effective in improving employee efficiency. I don't know. I'll try to stick to the legalities of it. So there's some stuff, and I don't know how if anybody's dealing with this, but there's software out there. I'm thinking, there's a program called Terramind, Interguard. These are all malwares installed on your computer. And what they do is they allow your manager or HR or whoever at the company to track your activities on the computer. Oh, sorry. I think we have a question here from Karen. Okay, so Karen's asking, I have filed a formal complaint against my boss for harassment. My employer has hired a private investigator to assess the situation. My biggest concern is that I get moved to a non-toxic environment. My question is whether they find her guilty or not. In your assessment, do you think my employer will move me? So Karen, that's a tough situation to be in. So I mean, I guess first of all, I'll say it's a good sign they've hired a private investigator and it's not just someone from the company investigating it. Hopefully that person's independent of the situation. If they find the person guilty, they have to take actions against her. And part of those actions should be, if you request it, and whether it's, I mean, I don't know too much about your workplace, but if it's reasonable to move you or move her, especially if it's, if it's a sexual harassment complaint, especially in those situations, yes, one of you should be moved. In terms of harassment, if it's just, non-sexual harassment, typically, depending on the workplace, it's probably, you can't insist for one of you to be moved. By moved, I assume you mean, move work to another workplace. So the biggest issue, Karen, for you, I think, is if they come back and say it's not substantiated, right? If they come back and say the complaint is not substantiated, that's a bit of a tricky situation, because sometimes, and I don't want to impute any, malintent on anybody, but sometimes the investigator, for whatever reason, may not be as independent or as impartial as you wish that he or she was. And just because the complaint comes back unsubstantiated doesn't mean that you're left without any remedies. Okay. So, it's the most optimistic situation, the best case. They come back and they say, Karen, we investigated. We found that your complaint was substantiated. We're going to take actions against your boss, right? And if it's a sexual harassment, yes, I think they have a duty to move one of you, right? Because that's way, they can't expect you to keep working with the same person that did that. So that's situation number one. Situation number two is they come back and say, sorry, Karen, we've looked into it. Our private investigator that we hired has found that your complaint is not substantiated. In that case, you should seek legal advice, because if the evidence is so overwhelming that there was harassment, whatever type of harassment it was, and notwithstanding, the investigator comes back and says, your complaints, we don't believe you, right? Or it's not, we're saying it didn't happen. Then you can claim what's called a constructive dismissal, right? And what that is saying, I don't know if you've heard the term before, Karen, but it's essentially saying, well, your conduct has by virtue of your conduct, employer, you have terminated my employment, right? The company hasn't explicitly said that they're firing you, but through their conduct, they're essentially repudiating the contract of employment. So all that means is no reasonable person would expect you to work in an environment where you've been harassed and the evidence is overwhelming. But despite all of that, the employer comes and says, well, we don't believe you. Nothing happened. Just keep working here. We're not going to do anything to change the situation. Right. So if that's the case, definitely seek legal advice. And if you want to claim a constructive dismissal, that means you would leave your employment and claim for severance. So Karen, I just seeing your message now. You're saying it's a non-sexual harassment. I have 10 pages with over 4 years with at least 8 witnesses. That's great, Karen. That's great. The witnesses are huge, right? Because if it's your word against your bosses, that's a tough case. If you have witnesses who have seen, or even if they have hearsay evidence, that support your claim, that's great. So Karen, I mean, it's if they find it substantiated, they're going to ask you what you want, right? And you can just say, well, I want my boss moved, or I want to move to a new department with a new boss. They're going to have to do something, right? Especially if it sounds like if it's over 4 years. If they don't take any action, go seek legal advice. I don't know if you're in a union or not, Karen. If you're non-unionized, I'm happy to talk to you about it. I mean, it might be a bit premature because you're still going through the process. If you're unionized, talk to your union rep, and because I mean, even the unionized environment, it's very different. You have to go through your union rep and through a grievance process. But if you're not in a union, I'm happy to chat after the complaint comes back. Yeah, so if you're in a government role and you're non-unionized, I can help you. And hopefully the private investigator comes back and says, yes, the complaint, is substantiated, and they're going to move you to a different department or get rid of the boss. They're going to have to take some action, right? And the degree of that action depends on the, I guess, how serious the harassment was. But if you have a certain outcome in mind that you want, so for example, getting moved to the department, and you ask them for it and they say no, they're going to have to explain why they can't do that, right? Especially if it's a government, if it's a big organization. I mean, if it's a small mom and pop shop, it's kind of impossible to move you. But if it's, I'm assuming if it's the provincial government, even a municipal government, it's a pretty big organization. So if they come back and find it substantiated, I mean, depending on the seriousness of the harassment, they're either going to have to move you, or they're going to have to take some disciplinary action from the disciplinary action against your boss. Okay, so I see we have another question from Jazika D. So Jazika D asks, what is an employee right? Who is a parent with respect to accommodation should the elementary schools close again if they can't go to work due to no alternative childcare available? Yeah, so I mean, there's protection for you, Jazika, if the elementary schools close again. We're all thinking of this another wave coming. Hopefully not. Let's hope not. But another wave that might come in the fall. I'm sure everyone's been reading about the variants, the Delta variant, and I think the other day I saw something about the Epsilon variant or something. Anyway, so yeah, if elementary schools again, I mean, your job's protected under the Employment Standards Act. It's also protected under the Human Rights Code, especially if you have childcare responsibilities. Your employer does have an obligation to accommodate that, especially if you're a single parent. You're protected under the Human Rights Code of BC and the Employment Standards Act. And Jessica, I mean, if there's any issues, I would reach out. Feel free to reach out. I think my contact information should be on the screen, or it'll come up at some point. But you should tell your employer, listen, our schools are closed. I have childcare responsibilities. I need a leave of absence. So that should not be an issue. If they give you a hard time, I'm happy to talk to you. And also, if anybody wants to check out our website, it's employmentlawyer.ca. A lot of these topics are covered in our blogs. We've written a lot of blogs on a lot of topics to do with COVID. There's a lot of good information on the site if anybody wants to check that out. Okay, so hopefully that answers your questions, Karen and Jazika. If for anybody that's joining us, as I said at the beginning, the purpose of this live session is to answer questions. I have things that I do want to talk about, but like I said, please interrupt me anytime if you have a question, and I will do my best to answer. Okay, so nobody else has any questions. I'll go back to talking about privacy, which and anybody dealing with these privacy issues, it's a very tricky area of law, and that's because there's not been a lot of cases in the past dealing with these novel issues. Oh, we have another question here. Okay, so I have a question from Shanila Mo. The question is, I work in a dental office and I've been working here for 9 years. Our office is in transaction to sell the practice. How can I get my severance package, or do I qualify for one? What if the new owner takes us on with my heritage, and I don't want to continue to work with a new owner? So Shanila, it's interesting. I just I've talked to some people recently about very similar situations to you. They were, hygienists, I believe. It's the answer is I need a lot more info from you. So I'll try to speak in general terms. I'd strongly urge you, especially if you've been at that office for 9 years, any paperwork, or when and if it happens, go talk to an employment lawyer, because you don't want to sign anything. If you could take away one thing from anything I say, don't sign anything without talking to an employment lawyer. So let me try to answer in general. When a dental office is sold, typically there's two ways to do it, right? Typically, the new dentist will buy all the assets of the old practice. So whatever equipment, whatever client list, the goodwill, and then they will also buy all the shares of the corporation. For the purpose of you, for your situation, all you need to know is, in general, your length of service will get recognized. Okay. And when the new owner, when the new dentist comes in, they're going to have a choice, right? They're going to either try to change your job, or they're going to keep it the same. If they keep it the same, you don't necessarily have to continue on. Again, if depending on the nature of the transaction, your employment could be deemed to automatically continue, right? Just with a new owner, with new management. There are certain situations where you can say no to the new job with the new dentist and claim for severance. There's 5 to 20 possibilities there's a lot of different possibilities in your case of what could happen, depending on the nature of the transaction, and what they offer you after the new owner takes over. If they keep your terms the same, and if all that's happening is that the new owner purchases the entire business, then you might not be in a situation where you can quit and claim severance. I would say in your situation, Shanila, definitely, when and if it happens, go seek some legal advice, and don't sign anything, because one thing you should watch out for is the new owner not recognizing your length of service with the previous ownership. That's something I see quite often in your type of situation. And I think that's probably the number one thing you should watch out for, right? Because if you sign something that says, we're going to take you on and we're not going to recognize your years of service, then the severance should really come from the previous ownership. So, I hope, I know that was a very, very convoluted answer. It was a complex question, and I hope I didn't confuse you more. I think the number one thing you should take away from my answer is just go get some legal advice when and if it happens, and especially if you're asked to sign something. And hopefully they, the new ownership just doesn't try to limit your years of service and keeps your job the same. Okay, so No problem, Shanil. So Yonkers Honkers, his question is, do you know who Joe is, my brother? I do not. I do not. Okay, so anybody joining us, please feel free to ask any questions. I'm here for the next 10 minutes or so. And just throw them on the screen if you have anything. Yonkers, if you have any legal questions, I'm happy to answer them. So back to the topic of employee privacy. Like I said, it's you might hear different opinions from different lawyers on this stuff. I don't know if anybody in the audience is dealing with this, but being monitored while they're working remotely, I guess the short answer is, depending on what your employer does to monitor you, it could be allowed or impermissible. One of the recent cases in Alberta, I think there was a young woman. She was a custodian at a school. I think her name was Michelle Dion or something like that. She was a custodian at a school, and her employer, so the company that was providing the services to the school, made her download an app. It was basically a location tracking app on her personal phone. All right. So she said no, because she had no idea, what this app did, or what it tracked or what it didn't track, and if it tracked her outside of work hours. But essentially, the purpose of the app is to make sure she was working during hours of work, right? And I guess the app created some sort of geofence around her area of work, and it would alert the employer if she went outside of that geofence. So if the location went outside the geofence, her employer would know. And that was how the employer tracked her to make sure she was working, essentially. She was eventually fired after she refused to download the app on her phone a month or two later. And in the termination letter, the employer said, "You didn't download this app, and therefore we're going to let you go." So if anybody is dealing with that type of situation, don't accept it at face value, because in that situation, I'll tell you right now, the employer cannot do that. There's no way an employer can make you download a app on your phone, on your personal cell phone, that tracks your location, and you have no idea where the data is going, and then fire you, a month later because you didn't do it. That's not a reason to fire someone. And Michelle is very likely entitled to severance, and it could be a fair bit of severance, depending on the how long she worked for this company, and obviously your age and length of service. So just for anybody that's being asked to do things on their personal devices, you have a lot of rights under BC legislation. We have the Privacy Act. We have, the Personal Information Protection Act. If you're working for the government, there's a separate piece of legislation for that. There's a lot of legislation protecting employee privacy rights. If you're being asked to download some sort of malware on your personal laptop, so that you can work from home, unless the only situation where the employer may be able to ask you to do that, if it's in your written employment contract, and from the outset of your employment, the company said, as a condition of employment, we need you to do this. That's the only situation where I can see the employer may have grounds to actually make you do that, because you agreed at the outset of your employment. So for anybody dealing with monitoring, or if they're not comfortable with the level of monitoring that the employer is imposing upon you when you're working remotely, let me know. My contact information, as I said, should be on the screen or coming up on the screen. If you're uncomfortable with it, especially, there's probably something I can do for you, whether it's it's typically a complaint to the privacy commissioner. Um, you have a right to know how your data is being used and what data is being collected. So just keep that in mind. If the employer is doing something that you think invades your privacy, it is making you feel uncomfortable, just know you have rights, right? I mean, the employer is not just all powerful person that can just track you 9 to 5 and install a video camera in your home office. Um, okay, so sorry, Yonkers. I'm just getting to your question now. Is it okay to pirate movies? Uh, No, you can't pirate movies. I mean, pirate movies is by definition illegal, right? And you're saying your employees have been doing this on my Wi-Fi. I mean, you should probably tell your employees to stop doing that. And if you can prove it, if they admitted to it, you should probably create a policy regarding Wi-Fi usage. And it's illegal activity, right? It could be a basis to discipline them. And so, yeah, I mean, I would create a policy as to Wi-Fi internet usage for your business immediately, just to make clear what you can or cannot do. And so certainly our firm can help you with that if you need. But that sounds like a basis to discipline your employees, at the very least. I would at least say to them, hey, give them something in writing saying, you pirated these movies on dates XYZ. This is a illegal activity. And it sounds like they could be, it could be time theft, right? If they're doing this at work while they're supposed to be working, they're obviously not doing their job. So that could be something else that you need to talk to them about. So yeah, I mean, Yonkers happy to chat with you more about it, if you need any help with dealing with that kind of stuff. But yeah, I mean, number one, you should make it clear to your employees that's not acceptable. Okay, so Arlene has a question. My manager threatened termination of a coworker if he didn't agree to change a signed arrangement of 3 static days. Arlene, if you just clarify that question. So your coworker didn't agree to change a work schedule or 3 working days, or what was the employer trying to change? Didn't offer anything in return. Can you do that? So Arlene, can you just clarify what the employer is trying to change? Like, what is the situation now, and what are they trying to change that situation to? And then I'm happy to answer that question. Patchy the Pirate and asks, how long does unemployment last during the pandemic until it ends? My dad is having that trouble. Patchy, I think if you just there's a link to the Service Canada website. I know it depends on I think your contributions and how long it lasts and the unemployment rates. It should be an answer you can find on the federal government website. I don't want to tell you the wrong thing. I imagine it ranges from 8-10 months, but it should be an answer on the federal government website. I don't know the exact answer sitting here, but it should be on hopefully a easy thing to find on their website. Okay, so back to Arlene's question. This is the last one I'll take for the day, because we're coming up on time. So your colleague, Arlene, he worked 3 days a week, and now they're changing to any time during the week. No, they can't do that. If he was working 3 days a week, they can't just unilaterally change it. He wants, well, it depends on if they're changing his shifts, then it depends on if he's had shift changes before, right? If they're just changing his shift, and it's always been changing week to week, then that's probably something that they're allowed to do. If he's had the same shift for a few years, and now they're saying, we're not going to guarantee you anything, and you have to work maybe weekends, they can't do that. They can't unilaterally impose that because it's a fundamental change to the employment contract. Your colleague should probably, he might have a case for constructive dismissal, meaning that he can claim for severance, especially if they're not giving him anything in return. If they're just saying, hey, Mr. Smith, here's the deal. Here's a new term of your employment. They cannot do that. Tell him to seek some legal advice, because one of his options could be to just claim for severance and leave that job if he wanted to, right? Anyway, guys, thanks to everyone for joining us. We're all out of time. I'll be around again in 2 weeks, so apologies if I didn't get to anybody's questions today, but I'll be around. I'll be back in 2 weeks to answer to answer any more questions that I might have missed. So yeah, thanks everyone for joining us, and hope everybody stays safe and have a lovely long weekend. Oh no, not a long weekend. Have a lovely weekend.